rise.
Morning. You may be seated. So we are here in our case number 1, CACV 170342FC, Lynum versus Tavares. As you know, as your lawyers know, each of you is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if, when you approach the podium, you give us your name and the name of your client for the recording. We have studied the record in the case and the briefs. We've also discussed the case in our conference together. So with that, Mr. Berkshire.
May it please the court, Keith Berkshire for petitioner, who goes by Nick Lynum. The issue in this case, the main issue from father's point of view, is whether he was provided adequate notice of the change of position from mother of the amount of the arrears that she owed, or that father owed. In mother's petition to enforce, she pled very specifically an exact number for both child support and spousal maintenance arrears. For child support, she pled $30,000. For spousal maintenance, she pled specifically $87,500. Over the year, in excess of a year that this case went on, I think it was exactly 13 months, less than 2 weeks prior to the trial, mother disclosed for the first time an expert report. While she had disclosed the expert 5 months earlier, the report with the calculation of father's alleged income and therefore the arrears based on this formula from their decree was disclosed for the first time 2 weeks prior to trial. Mother's position as far as what father owed and what his income and so forth was in her own pleading was disclosed for the first time 1 day prior to trial on September 13th in her pretrial statement.
Though, that she was looking, she said she didn't give a specific amount. She said she needed to determine the amount of arrearages through an expert. Wasn't it clear that she contemplated doing some sort of calculation through the expert?
I think it was. I think there was also another pleading. I think the response to my client's, I think it was a petition to modify child support. She claimed that he might owe in excess of $200,000.
So if you couple that with at least a significant portion of the delay seems to have been occasioned by your client's failure to provide documents that were requested, why does that not militate in favor of saying, yeah, it was late, but it was late because the information wasn't provided earlier? Well,
If that's the case, I mean, here we have such a very specific pleading. If mother would have pled, I mean, this somewhat relates to if it was a default proceeding. Somebody sues me on a credit card for $15,000. They don't show up to the hearing and say, I owe 30. I mean, they pled a specific number. And if we look at cases like the Ammer case where it says if there's an express allegation, I mean, here you couldn't be more express than an exact number. And to go back, mother had repeatedly in prior enforcement proceedings against father never alleged that he owed more than the $3,500 or $1,750 when it was cut down for spousal maintenance. She had stated it in multiple pleadings that was the amount owed.
But let's say there's clear records that show that he was actually making $5 million a year. So she neglected, or she just overlooked or didn't pursue that. That doesn't really change the analysis of whether she would be entitled if she can prove that going forward, would it?
I would agree. However,
and the language of the decree didn't change over time, right?
Well, no. The only thing that changed was that at some point the $3,500 went down to $1,750. The spousal. I mean, the formula didn't change. You're correct, Your Honor.
And the husband was aware of that formula from the time of the decree forward. He had that notice.
Of course. However, the issue, though, is what is her actual position on his income? I mean, here we have a 13 months of litigation where he learns the day prior that this is her claim as his income.
But what do you do with that? It's over $200,000 in arrears. Doesn't that suggest there's there's something.
Even if that's notice, he
Wouldn't
still
that be
doesn't
on
know.
notice, and don't you then try to
Serve an
depose the expert
interrogatory.
or figure out?
How is he supposed to depose an expert with 10 days when he didn't get the expert report to? I mean,
Oh.
you have 10 days to depose an expert. He got the report 10 business days prior to trial. I mean, the discovery deadlines had passed. Frankly, their deadline to admit the report had passed. There's a big confusion from the trial court. If we look, I think it's pages like 152 to 172, where there's some statements that this was disclosed earlier, or there are dates earlier when it was clear that it was not. The date of the report is August 31st, so clearly it couldn't have been disclosed prior to August 31st. I think the actual date of disclosure was September 4th. If that's the case,
But how
ju-
about if the reason for the delay is attributable to?
then
to
then
your client?
file a motion to compel and sanction him, and he's then entitled to an actual hearing on the motion, which wasn't happened. This is especially with spousal maintenance and child support. I mean, it's jailable. 1 day notice that you're $400,000 in arrears can't be due process.
Did he serve interrogatories? I mean, the problem, you're in a tough spot here on appeal, because I don't see, you can't argue that the report was late by virtue of any pretrial order. I don't see a motion to compel interrogatory responses. I mean, he's.
Well, the report was late. There's a clear deadline that Judge Fox went through.
But that's not an argument raised on appeal, because I think the defense to that would be so powerful. The expert did the report, I understand it goes the argument, as soon as he could, given the tardy disclosure, so.
I think their actual defense was my client was the first one that referenced it, but so the
referenced-
report at trial.
Oh, really?
But
Okay. Well,
Again, this comes down, this still has to have, I mean, notice is essentially a due process argument. It's, did you have a fair chance to litigate it? If all the fault falls on my client,
Did he
fine.
request more time at that point?
No, but he repeatedly objected, saying that he couldn't get his exhibits in, because he then, as soon as he gets the report, a week prior to trial or 2 weeks prior to trial, he tries to, as there's plenty of testimony about, he tries to go through and admit additional exhibits. He says he's working through the night since he got the report to admit something, to get these exhibits put together. The court precludes all of his exhibits that would.
Once they're precluded, does he say, I need more time then to rebut the expert's testimony?
He never specifically asks for more time, Your Honor. But I'd also point out that.
Why isn't that significant, though? Doesn't it become kind of a strategic decision if?
No, I don't think so. And I mean, to go back to one of the main cases we cite, which is one of mine, which is the Volk case, the record in Volk was exactly, I think, 12 minutes long. And the objection where this court found that there's no magic word needed in objection. In Volk, what happened was my client had a lawyer, not me, that in trial, my client's standing up in the background yelling that he needed to admit exhibits, and he needed to discuss exhibits, and he needed to testify. I mean, this court found that the magic words of objections aren't objection, Your Honor, I need more time. My client tried to admit exhibits. He tried to go through, once he got this expert report, which was late, unquestionably late per the court's deadline, then he tried to admit stuff which was all precluded. So he has a significant harm when he learns of their position 2 weeks earlier. Did he know that they wanted in excess of $200,000? I'd argue that it was in response to another pleading, not proper notice. They never amended their petitions properly under the rules.
You have to
under
amend
34
and specify the exact amount? You have to
I
file
think
an
you do
amendment at that point.
I think you do when you specifically plead an amount. If they would have said he owes arrears under the decree, I would agree that there probably doesn't need to amend an amount. But when you say he owes $87,500.00, you pled something so specifically that I think you do have to amend it. It's like adding a defendant.
I mean, when you file something else that said it's probably in excess of $200,000.
They never specifically amended their pleading. I mean, family court, they could have put that in a child custody petition. It wasn't an amendment to the pleading. We still have rules in family court that say you have to specifically amend pleadings.
what's the best case for the fact that you can cite that a party's bound to seek no more, is entitled to no more than what she has pled?
I would think it be the Supreme Court case in Armour, where it says when you specifically plead relief, you have to amend.
Okay.
So the specific quote, parties are bound by their pleadings and evidence may not be introduced to contradict or disprove what has been admitted or asserted as a fact in their pleadings, and a party may not introduce evidence in contradiction of express allegations in their complaint.
Okay. We'll take a look at that. I'm curious about the Chicago condo.
Okay. Well, the testimony from my client, and one of the things.
What's the test? What's the test? That I'm intrigued by the argument that you make about the lawyer who has a 4-month trial in Chicago. Right.
Well, and I think this is my argument. I mean, this is one of the problems we run into with pro per divorce decrees and decrees that are, not as specific, is then when you go to modify them, what is the change? Who has to prove the change, and how do you prove a starting point? Our argument on this is basically twofold. We've got a law of the case argument, where one of our problems with Mr. Cantor's report is it doesn't actually cover the decree. So it's like me saying, how fast are you going? 55. Is that miles per hour or kilometers per hour? It's 55. So his report doesn't go backwards to say what his analysis would say my client's income is at the time.
But at the time of the decree, did they have to specify what the income? Didn't you say you're going to pay the? I thought it was, and I might be misremembering. Wasn't it just there's a floor of $3,500, and then we'll see how much you make at the end of the year?
There is. However, the parties also specifically stipulate to a child support worksheet that attributes my client income at that point. So the parties agree. I mean, child support worksheets are binding on income. They agree that his income for child support, that as of that date, that's what he makes. So if in the future it changes, but we have to have a starting point. And allowing an expert report to come in that doesn't show the same analysis at the starting point. Because if that expert report said $300,000 at the starting point, then their $300,000 specifically excluded certain items. One of the things that both parties testified about.
That just go to his credibility, and isn't that just a way you poke holes in what he's saying? And if I'm a trial judge, I might want to know that.
But even Mother testified, specifically, you don't have to rely on my client's testimony here. Mother testified that his job, his travel, these condos and things at these other locations existed at the time they got divorced. They said she's testified that he did the same thing then as now. So if those things, if they're saying that his income is $100,000 then, and she agreed to it by signing the decree, which incorporated a child support worksheet where they agree that that's his income, because, again, their decree says the court adopts the findings in the child support worksheet, and those findings are income figures. If they agree to that, then she's essentially agreeing to keep those figures out of his income. Now, again, they weren't as specific, but that's why the analysis Mr. Cantor's analysis needs to be started from 2010 when the time of the decree, so we know, is there a change? If they said 300 really means 100 because we're keeping out 200 of your perks or other things that business expenses, then that's the analysis to show, is there a difference?
Is that the argument? Anything that kept him from making that argument to the trial court to say
he did make that argument. He stated that these were still things he asked.
But then I take it he didn't submit records to show. I mean, there seemed to have been a problem with not having a lot of records, and the courts doing the experts are doing some extrapolation. What was? Well,
and to get into the extrapolation issue, they have the credit card statements, but Mr. Cantor says he only went through six months of them to come up with this 44%, or the court used 44%, that he looked through 6 months and then just applied that same percentage backwards. First off, that's not an approved business, a methodology to come up with income. You have to look at the entire period. It's not my client's obligation to say that your extrapolation is wrong. It's theirs to say it's right when they're trying to say that his income is a certain number. I mean, extrapolating 6 months over 5 years cannot meet any sort of professional standard of income. I mean, this is, again, what my client tried to introduce is the fact that, the Home Depot receipts of buying 70 toilets and all these types of things, that he was precluded from doing so because he learned the day prior that they're saying his income is $700,000. And that's the big issue here. The issue is the court precluded his evidence but by allowing his evidence to fall under the standard of 30 days, but based on this late notice of the claim. My client had no notice to prepare. Did he have late disclosure of credit cards and so forth? Fine. If that's the case, hold a proper hearing under Zimmerman to say that you're sanctioning him because of a discovery issue. The court didn't do that. They didn't sanction him via discovery. He just never noticed that there was a hearing on discovery. They just ruled against him based on, again, the notice here, 1 day notice that you're going to jail over an additional $300,000 above what was pled. That's our main and biggest issue here, is how can that be due process, especially on something that, again, where you're going to be incarcerated. This is one of the issues in Volk, why it was taken so seriously by this court, was attributing Mr. Volk in that case $14,000 a month when he made $2,000. He can go to jail for it. And that's the same issue here, that spousal maintenance now under the statute change from a couple of years ago, you can go to jail. And that's why this issue is so important.
I derailed you from Johnson's question.
I haven't
on
heard about Chicago yet.
Okay.
What distinguishes Chicago from LA or Phoenix?
Well, the only testimony about Chicago was my client's, about that his entire business uses the place there. I
Is
forget
that
if
where
it's
the office is? His office is?
He works out of multiple locations, but that is where one of his main locations is. I mean, it's rented by the business. It's not in his name. It's rented by Glasser, I believe is the company that rents it.
Isn't the Arizona and California resident, aren't they also rented and not in his
I
name?
don't remember if those are both rented in the business names. It wouldn't surprise me if that was the testimony.
not the determining
But
factor.
the only testimony was from him that other people, that everybody from his office uses this place in Chicago. I mean, I used to be a consultant. I used to travel all over the country. And if you attributed me because I had to be someplace, that is income. There's a reason it's tax-free and per diems are tax-free, because it's not income to you. It's an expense related to a business. Is there an argument on Phoenix that or potentially California from those being personal? Maybe. But Chicago, which is the biggest one, I mean, I think it was to the tune of almost $7,000 a month.
Did wife offer contrary testimony suggesting that
No,
he
and
went to Chicago for pleasure as well as business?
there was no testimony from wife on this, but wife did, or the testimony from wife on the issue was limited to the fact of he did that all at the time that we got divorced. Nothing's really changed. He traveled, he had business, he was doing deals all over, and he had these locations before. Again, Mr. Cantor's report on these issues, the sole evidence that he has is what wife told him. But wife, I mean, he didn't interview my client. He didn't go to the locations, look at, travel logs.
What was it that wife told him?
Just that he had these locations. And again, some of these that they attributed him didn't actually exist. I mean, the testimony and the things that my client was not allowed to present said some of these locations didn't even exist during these periods, or he wasn't even there during these periods. So, I mean, again, when he learned so late, I mean, it's this, you disclose something late, unquestionably late, 2 weeks prior to trial, your expert report. And then my client's precluded from rebutting any of it. I mean, most expert reports, or at least under the rules, not under this minute entry, under Rule 49, expert reports are due 60 days prior to trial, because most disclosure deadlines are 30. It gives you an opportunity to rebut it, not get this last minute.
It is entirely attributable to your client not providing the information, and then so then the expert does it within 3 days after getting the information from your client. Does it not shift at least a little bit of an onus onto your client to say, well, I need more time if this is to be able to rebut this? And without that, why?
And again, Your Honor, I think that goes to this, his request. Is the objection mandatory to say, I want a continuance? Or is the objection wording, I object to this coming in enough, which he did. He objected to their change of position. I mean, it's up and down. There's 25 pages of discussion in the transcript of the lateness of this and the discussion about how late everything was from his end, and from mother's end. So I don't think that this court's ever held, or Arizona's ever held, that the objection, I need more time, versus objecting to the premise coming in, that there's really a distinction. I mean, he objected to essentially going forward, having this come in. And I think that's enough of an objection the court should have just continued it. I mean, that's what the court should have done. The court flat out stated if the expert report was late, it's not coming in. The judge specifically stated if Mr. Cantor's report is late, it's not coming in. Then there was clearly confusion about when it was disclosed, because the court presumed, based on some of the statements, that it was disclosed August 4th, which it was not. It was clearly disclosed in September. So that's the issue with notice. I want to save my last minute and 3/4.
Thanks.
Good morning. Sherry Shepard representing Tiffany Tavares. My colleague Stephen Everts is also here today, who helped me, collaborated with the brief. Husband's argument seems to rely on disclosure in this case. Mother filed her petition to enforce spousal maintenance arrearages, child support arrearages on August 18th, 2015. But she also filed a request for husband's address and his financial information, which in the body of that pleading specifically says there is a sliding scale on spousal maintenance, so she needs his financial information. Then both parties were put on notice on October 14, 2015, when the state itself filed a notice of its inability to even calculate the arrearages in this
Can you
case.
help us out? Why was the state involved? Why did the state get involved?
Mother resides in California. So when Mother has filed multiple petitions to enforce in this case, California and Arizona have got involved regarding the enforcement.
Is it it's not a 4D?
I don't get the impression that it is a 4D, but the state is involved.
Okay.
So, and I think it's due to the enforcement and with the two states talking to each other.
Okay.
But both parties were given 11 months' notice by the state that they couldn't calculate the arrearages. Mother filed these pro per. Father would come to this court today telling this court that a pro per petition should be held to the penny of the calculation in her petition, when she also filed something saying there was a sliding scale and she needed his financial information, and the state, who keeps track of the payments, could not even calculate the arrearages without knowing Father's income.
What's your response to the suggestion that the original child support worksheet at least set a baseline for this is the income in the year of the decree, and without any kind of expert testimony, without being able to show that I'm using the same methodology now that was used at the time, that does create a pretty big surprise for husband if you're not going to hold the parties to the same methodology that was used at the time that they agreed that this is the income for child support purposes.
Well, in the consent decree, there is nothing in the decree at all which states how the parties determined Father's income. It didn't say, oh, Father's taking a paycheck. The consent decree does not say we attributed Father's automobile expenses that are being paid by the business. The consent decree is silent. Father is the one. The consent decree puts Father at $96,000 a year. Father filed a petition to modify child support saying his income has dropped, and then he goes to court and he says, oh, my income is $100,000, oh, maybe $85,000. So the decree is silent, and that was 6 years earlier. The court has the way that the spousal maintenance. Well, first, Father filed a petition to modify child support based upon his income, giving the court a duty to determine his income in 2016 as opposed to 2010. The court also, the parties, the way the sliding scale is in the consent decree, the parties have to make an independent determination of Father's income each and every year. It's an income-based spousal maintenance.
But if you're going to do that at the time of the hearing and Father has some documentations, when the expert report doesn't seem to have come in until shortly before the hearing, what's the best argument for just saying, well, the report's coming in, but Father can't provide any evidence to rebut it? We're going to keep out his exhibits.
So the expert report was Exhibit 28, and the expert supplemental report was Exhibit 29. If the court reviews the record, the court will see that Father himself admitted Exhibit number 29 into evidence, which was the expert's report showing what the expert believed his income was 2012 through 2016.
Think your client was not going to introduce the,
No, we were going to introduce it, but Father introduced it before we had an opportunity.
So you're saying that's a waiver of the argument? But of course, he was already testifying, right? The expert was going to testify, so, what, is your, to the extent that the parties now, that your client now would like to argue that gross income means not what's on the tax return, but instead means more than that, and the child support cases help us understand what gross income means. To that extent, what I understand Mr. Berkshire was saying is that attached to the decree were child support worksheets to which both parties agreed father's gross income was X, 96,000 or so. But that has to be wrong then, right? That has to be inaccurate if gross income today, using the same methodology, would be a whole lot more.
If I understand your question
That's not
correctly.
a very good question.
There's no evidence on how the parties calculated or came up with child support. They didn't go to trial. It was a consent decree. It was negotiated. Both parties were represented by counsel.
But isn't there evidence at the most recent trial from the wife's testimony that certain factual circumstances have remained static? In other words, that these residences, for example, existed at the time, that the manner of lifestyle was the same.
There's no evidence that these particular residences existed at the time of the decree. The parties owned a residence. Everywhere Father stays, which is in the record, is owned by one of his businesses. He says that his primary residence is in Phoenix, and it's owned by one of his businesses. He stays in Chicago at $6,300 a month. He receives mail at the residence. He exercises his parenting time at these residences. This is not, John Doe going on a 1-week business trip paid by his employer.
What's the test, though? If he owns a home here, I mean, he doesn't, but he owns a home here, also in L.A., he says, I'm in Chicago on business. What's the test to determine whether that is income or not? As opposed, the example, because we have to, when we're issuing our decisions, we have to look at how our rules that guide our decision making would apply in other cases. What's to distinguish his stay in Chicago from the stay of a partner at a Phoenix law firm who has to go try a 4-month trial in Chicago?
Father is the owner of these businesses. He gets to direct where the income is. A partner at a law firm who might go to a trial for 4 months, that seems like an exceptional circumstance. Father has testified that he is outside of Arizona more than he is inside of Arizona, that this is what he's done for years. The difference is he now says he works for Glasser Capital Partners, which didn't exist at the time of the entry of the decree. He says he owns 20 businesses, 6 which were active. We have no evidence whether or not these even existed at the time of the decree. The difference here is Father is a majority owner. He doesn't take an income.
But even if he owns the company, isn't it a
If all the
legitimate
clients are in
business
Chicago.
expense to go? That's your office in Chicago. They all go to the office. I mean, even assuming you're exercising some parenting time there, you're working and you have to be there. If you're staying at a hotel, you can exercise parenting time at the hotel. If it's owned by the business and is the office for the business, why would that necessarily be a perk for his benefit?
Because
and be saving him expenses when he's already being attributed with homes in Phoenix and California. And if his testimony is I'm only going there to do business, what would be the basis for charging that as income to him?
it is significantly reducing his living expenses. Father has no out-of-pocket rent, mortgage, utilities,
But we've
food
attributed
expense, or
year-round
anything
rent
else.
to him in Phoenix
And LA.
and LA. So it's not, if his business requires that he go to Chicago, and the business pays for it, no matter who owns it, even if he's the owner, that would be, it seems like a legitimate business expense.
It's also extravagant. Remember, Father's rent is $6,300 a month. Father's not staying in a $2,000 a month
The
apartment.
test? For
It
whether
is
or
under
not
the
We need a
guidelines.
test.
The test under the guidelines is, and I believe Baker states this, and so do the child support guidelines, that Section 5D of the guidelines say expense reimbursements or benefits received by a parent in the course of employment or self-employment or operation of business shall be counted as income if they are significant and reduce personal living expenses.
And how does the Chicago living reimbursement reduce? You're counting him LA and Chicago and Phoenix full freight. Every cent he spends in Arizona and California. So are the Chicago expenses reducing what we're counting for Arizona and California?
Father is spending 4, 5, 6 months in Chicago.
Right, but your argument seems to be he's staying in a lavish place. But if I'm going on business and the company pays for me to stay at the Ritz rather than Motel 6, do I have to claim the additional difference as income because my company is willing to put me up at a nicer hotel than Motel 6?
Why should Father live a 6 or 7 income figure while Mother is only living a 5 income figure?
Well,
Why is Father getting to direct this available cash that he has out of these multiple businesses, drive a 2015 Cadillac Escalade, not have one automobile expense, live in lavish apartments, while Mother lives on a 5 income figure?
counting all that though? We're just looking at Chicago and think of the consultant, Arthur Anderson, whatever it's called now, Accenture. He or she travels the whole year. Do we have to attribute all that expense income as his or her income for purposes of?
Even while they
Maintenance.
continue to maintain a personal residence?
He doesn't maintain a personal residence in this
But we have
case.
already, as we've said, we've already attributed the Phoenix and the LA properties. So let's assume for the moment that one of those is in his name, personal residence. Going to the consultant example. So do you then also attribute all of that business travel expense?
Well, the trial court in this matter only attributed those expenses for the months that he was there. It did not attribute 12 months. They may have a lease for 12
Did the court say,
months.
I think you were there doing personal business as well as work? Is that the
Father
basis for it?
testified that he was in Chicago for so many months in 2015 and so many months in 2016. The trial court made specific findings and only attributed Father income for Chicago for the months that he was actually living there.
So how is that different from my hypothetical about the trial lawyer, Phoenix-based trial lawyer?
Because this is regular and continuing. This is Father's business. I don't think that your Phoenix trial lawyer will say, I'm out of Arizona more than I'm in Arizona, which is exactly what Father in this case testified to. Father testified that he lives outside of Arizona more than he lives inside of Arizona. I think that's the difference here. But this court has broadly construed or broadly interpreted gross income. Father, in this case, would have gross income only be what's on his tax returns. But yet he testifies that when he was in Washington for 8 months, he took a U-Haul, he moved up there, he writes off 100% of his food. He testified if he's in Philly, he writes off 100% of his food. He has no transportation expenses. I mean, this court has already found that value of on-base housing is includable as income, that gifts of cash and mortgage payments on behalf of a parent is gross income. And the Cummings v. Cummings case also says that guidelines are based upon spending patterns of family at various income levels. Gross income is not determined by the gross income on the party's income tax returns, rather on actual money or cash-like benefits received that is available
Okay.
for
But I take you back
expenditures.
to Mr. Berkshire's argument on just kind of the late notice. I mean, what's your best answer to why that's not unfair when, why shouldn't the court have delayed enough to give husband a chance to rebut, and why keep out all of husband's documents at that point?
So exhibit number 28, when it was admitted into evidence, husband did not object to its admission. It wasn't until exhibit 67 came into evidence, the 1,292 pages of American Express credit card statements that husband was actually objecting to, stating he didn't get them until the day that exhibits were due to the court. Then there are probably 10 pages of transcripts where the court clearly goes through my disclosure statements to husband showing that they were actually mailed to him, I believe, on August 4th or something on a CD to his Phoenix address, and they go through that. Now, husband, I emailed him, he was disclosed the
When did he get the expert
report the same day we got it,
Which day was that?
which was approximately, I think it was August 30th.
So less than a week before trial.
No, it was 15 days prior
Oh,
to trial.
okay.
Trial was September 14th.
Okay.
When we went to court,
Yeah.
when we went to court, the first question out of the judge's mouth, the very first question was, is everybody ready to proceed to trial today? I answered affirmatively. Mr. Lynum answered affirmatively. Mr. Lynum was given an opportunity to say, no, I just received this 15 days ago, and I'm not ready to proceed. The exhibits that father was trying to admit were a year old. He had plenty of time to disclose those if he chose to. He did not disclose them until he submitted them to the court the day the exhibits were due. That's the
Presumably,
difference.
He didn't know that they would necessarily be relevant until seeing the expert's report. Is that his position?
He didn't put that position, I don't recall any testimony about that position in the transcript. He was mostly complaining about the American Express exhibits that were sent to him on CD on August 4th, almost 45 days prior to trial, because he was in Chicago.
Are payments associated with the homes in LA and Phoenix on the Amex statements, or were those separately documented?
We have never received disclosure of what is being paid in Phoenix on father's behalf, despite propounding formal discovery.
In California?
In California, it was clearly stated on his bank records, NoHo Commons, it was like $2,184 per month. Mother testified at a minimum to her knowledge that he had a residence there to visit the children through at least November of 2015.
Okay.
The trial court was given a duty to determine father's income for 2012 through 2016 on father's petition to modify child support, mother's petition to enforce. The trial court did not abuse its discretion. The record clearly supports the trial court's findings. Father admitted that the American Express documents were had personal expenses. The court used its discretion and only attributed 44% for television and shopping and things that are clearly personal. We would argue that this court should affirm the trial court's ruling.
Thank you.
Thanks.
Respondent doesn't cite any case law that says we use child support guidelines for spousal maintenance determinations of what a gross income figure is in a decree for spousal maintenance. Child support guidelines specifically say these are for child support, and that they use a much broader, I mean, one of the first sections of child support guidelines says the definition of income for child support purposes is not that the same as for tax purposes. But it says for child support. I mean, we don't have this. There's obviously an issue here of what the decree meant. That's an interpretation issue. But nowhere in the decree says we are using the child support definition of income for the determination of spousal maintenance. There's no case law that says we use that. Every case she cited, Cummings, Hetherington, all these cases, they're child support determination cases. They're not spousal maintenance. Not a single one of those stated that this was income or resources for spousal maintenance.
I thought you were saying, though, and I'll give you an extra moment to add, I thought you were saying that the parties agreed that his gross income was $96,000, and how they agreed on that was in the worksheet, and she's bound by that.
And that's my point, is that even under the broader child support definition, they used that figure. And I think what Judge Catani was asking, and you as well, Judge Johnson, was that we don't have the starting point, and that's the big issue here on the expert report, beyond the notice claims, which you've heard me say enough about, I think, is how do we know it's not the same calculation? You're not playing on a level field when they came up with this figure via consent at the time, but we don't know how because no evidence was put into record. They used an expert that specifically didn't go back that far.
Concern with that would be, was that argued, that's part of the experts there and testifying, or the reports there. Don't you make that objection? Isn't that something the court factors in and says, this expert is not reliable? Maybe the expert has a reason for changing the methodology, but was that argument raised with the court below?
And I'm out of time. I'll answer a few. I mean, only to the extent they asked both parties. My client testified and asked both parties that this had always been the case, that he had always traveled, that his business had been the same, and both parties stated it had always been the case. Again, that was some of the evidence he wanted to bring in, was that this was always the case, that was all precluded because of the late disclosure of the expert report, was what he was doing at the time of the decree, how it hadn't changed. But all of his done was precluded. Page 4 of the transcripts where he starts objecting to everything coming in. He objected from the get-go.
But if I could just keep you for a second. I'm
as long as you want, Judge.
A little bit puzzled. The decree comes out, but I don't know that there's any. So that's what, let's say wife assumes that, yeah, the income is $90,000 or say $100,000 for this last year, and that's what we're doing for child support purposes. But there's nothing that says I necessarily know that that's what even assuming you agree right then, because you don't make that first computation until after the first year for what's owed for spousal maintenance, doesn't it contemplate that we're going to look and we want to do an analysis? And if she just got it wrong for purposes of child support, would that mean it's also wrong to now change the spousal maintenance at the end of the year when she gets actual numbers? Let's say he just has W-2s that say, I make $3 million per year. Well, you agreed in the child support provision that you only make $100,000, but now you have W-2s that say you make $3 million. Why would that agreement on the $100,000 be controlling as to what you're going to get for spousal maintenance going forward?
Because the court's always held that you had the opportunity to be heard on it, the opportunity to do discovery on it at that point. You don't get to claim you didn't have the knowledge because you didn't look into it. I mean, that was the starting point you agreed to. You'd have to file a motion.
You agreed to look at the income every year.
But if you wanted to change what the original, how it was calculated, I think you'd have to do an 85C motion to set it aside. You agreed to this calculation. And that's what that same calculation has to be used.
Have I agreed when you have W-2s a year later that say you make $3 million?
I think that as of that point you agreed. I think you've agreed. That was your chance to look at it.
Enough? All right.
Sorry.
Thank you.
Thank you to both of you for your argument and for your briefs. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.